Thank you, Chairperson. Ladies and gentlemen, on Monday, the 2nd of February 2015, the High Court in Botswana delivered a judgment in a constitutional challenge to the Adoption of Children Act. The Act allowed that a child who is born out of wedlock could be adopted by a third party without the consent of the child's biological father. The applicant in this case, the biological father of the child born out of wedlock, argued that the Act violated his constitutional rights in a manner that is not in the child's best interests. The government argued that the Act was constitutionally justified. My brother, Judge Tingake, held that it is irrational to discriminate against unwed fathers. He declared that to the extent that the Adoption of Children Act did not require the consent of an unwed father prior to adoption, it is unconstitutional. Of course, in this case, the Attorney General sought to rely upon the terms of customary law, whereby a child born out of wedlock belongs to the mother's family, and argued that this is a position that was also applicable under common law, with parental rights and responsibilities over a child being acquired by birth in lawful wedlock. Under such circumstances, the biological father is, for all intents and purposes, a simple stranger. And the Attorney General justified that position by referring to the, and I quote, surreptitious nature of conception, end of quote. Of course, in reaching his decision, the judge conducted a purposive and dynamic interpretation of the relevant sections of the Constitution and also applied comparative law. The judge thereby considered both the best interests of the child, which is constitutionally protected in most common law jurisdictions, and in the international concepts of equality and non-discrimination, under which the requirement of a mother, but not a father, to adopt a child out of wedlock qualifies as an unfair gender discrimination. In the event that the government does not appeal this decision, this law, which is based on culture and tradition, will have been permanently obliterated from the laws of Botswana. And this was not the first case where an apparent tension appeared between the Constitution and custom, or the Botswana custom. Only 3 months earlier, on 14th November 2014, the High Court of Botswana rendered a judgment on the review of a decision by the Director of the Department of Civil and National Registration to reject the registration of a society or an organization called Lekadibo, a gay and lesbian group in Botswana, in terms of the Societies Act. The director argued that the Constitution does not recognize homosexuals and that the objectives of the organization are contrary to Section 7.2 of the Societies Act. In this instance, I should mention that homosexuality is a criminal offense in Botswana. There have been cases where the court ruled in favor of the government because, in their view, the Botswana society is not ready to accept homosexuality, although there's no documented proof of this. It is also felt that homosexuality is un-African and therefore against culture and traditions of the country. In this case, the judge, however, pointed out that the objective of the group was merely, and I quote, to carry out political lobbying for equal rights and decriminalization of same-sex relationships. And he went on to say that there is inherently nothing sinister or unlawful about the process of lobbying and advocacy, end of quote. This case is being appealed by the government, partly on the ground that if the group is registered, then this will violate the penal code that criminalizes homosexuality. It repeated its argument, that is the government, that the Constitution did not recognize homosexuality. And again, in reaching its decision, the court highlighted rights of such group association, expression, freedom of expression, etc., and refuted the registrar's allegation that the Constitution did not protect homosexuals with strikingly clear words. And in that regard, it is worth reading the judge's explanation of why a state's criminal code may criminalize engaging in same-sex relationships, while its Constitution's Equal Protection Clause prohibits discrimination on the ground of sexual orientation, and I quote, "It may be that engaging in homosexual activity is outlawed, but if I were to use an example of one born left-handed, if it was a crime to write with a left hand, such a person would not be punished for being left-handed, but for writing with a left hand, just as a gay person would not be punished for being gay, but rather for engaging in same-sex relationship," end of quote. The irony of that statement, in my view, is that it was probably intended to predictively counter the government's fear that if the group is registered, then this will violate the penal code that criminalizes homosexuality. But basically, it does the opposite, because it tries to artificially and very eloquently, I must say, separate a person's legal sexual orientation from the allegedly illegal exercise of that orientation. In other words, criminalizing to write with the left hand may in theory still allow the person to be left-handed. In actuality, it means nothing else than criminalizing all the left-handed. For it seems hard to be left-handed without writing with the left hand. Finally, in 2012, in a case named Musi and others, 3 sisters, and these were 66-year-old, 65 and 64, they disputed their nephew's right to inherit the family home under customary inheritance laws that favored male descendants. The High Court in Botswana ruled that these laws were unconstitutional, asserting for the first time the right of Botswana women to inherit property, and of course relying not only on the Constitution, but also on international standards. All these 3 cases exemplify an apparent tension between the Constitution of Botswana on the one hand, which has been inspired by international legal instruments such as the European Convention of Human Rights and so forth, and of course the Botswana customary law, which is still a crucial source to solve legal disputes in Botswana. Now, Botswana is still governed by a dual legal system consisting of the government's civil courts and traditional customary courts, and the latter found primarily in rural areas. And of course, the country is, as some of you know, is rule of law compliant. Customary law in that regard is defined, and I quote, as in relation to any particular tribe or tribal community, the customary law of that tribe or community, so far as it is not incompatible with the provisions of any written law or contrary to morality, humanity, or natural law. Yes, I've noted that. I'll skip the rest. And I was just going to say that Botswana is not unique in its application of customary law. Ghana, for instance, does it. South Africa does it, but it shouldn't be inconsistent with the constitutions. Now, the Constitution of Botswana disallows discrimination, and I'm going to share with you one last case, if I may. A Botswana woman called Unity Dow married an American man, Peter. They lived in Botswana and ultimately had 3 children. And under our custom and culture, the 3 children, now look at it, are properly Mr. Dow's, because they take his name, they take his totem and his nationality. This meant that the 3 children were not Botswana for all intents and purposes. And every 2 years throughout their lives, their parents had to apply for a residence permit. And yet they were born in Botswana, raised in Botswana, and their children lived in Botswana. Unity ultimately approached the courts on alleged discrimination and lack of protection of the law. And she successfully did this. The Attorney General appealed, and the Court of Appeal, in dismissing the appeal, noted that the Attorney General still demonstrated a continuing reluctance to extend equal protection to women on the ground that the framers of the Constitution deliberately intended to discriminate on the basis of sex, because Botswana is a patriarchal society. And of course, the court used all sorts of international standards, including the African Charter on Human and People's Rights. Now, we are very happy that our courts in Botswana are beginning to come to the table. They are striking down these repugnant, mostly repugnant customary rules and laws. And our judges are doing this in a very brilliant fashion, like Judge Dingake that I've just talked about. I'll skip a lot of what I had, but at the end of the day, really, in this modern understanding of the constitutional interpretation that we are witnessing in Botswana, it appears that our courts are moving forward. And for me, the most important thing is also a demonstration that courts in developing countries are becoming more and more independent, and this is what we have been advocating for. And this is not peculiar to Botswana. If we had time, I could share many other cases from Zambia, South Africa, Namibia, and so forth. Chairperson, I thought I should share with you this different dimension to the topic, to the main topic. Thank you very much.